Welcome back. We have promised that we will do this segment a bit just now, and of course this is regarding the Federal Court ruling that the Selangor State Legislature is incompetent to pass a shariah law that makes it an offence to engage in unnatural sex. Chief Justice Tengku Maimun, who chaired the 9-member bench, said that the primary power to enact criminal laws lies with the Parliament. That is the Federal Parliament, not any state legislators. And of course, when we talk about this over the course of the evening, we've had a lot of experts on. Many of them are legal jurists. Some of them are people directly impacted by this, including NGOs and NGIs discussing this. So right now, we just want to do a quick recap before we end the evening to understand just how significant this ruling is, or if not significant at all. So joining us is Arik Zakri, a long-time friend of mine. Arik, how are you?
I'm great. Alhamdulillah. How you doing, Ibrahim?
Fantastic. But I just want to see what is the whole hoo-ha about the situation is. And prior to getting you on the show, you were telling me that the issue is actually quite simple. So let's simplify this ruling here.
Okay, Malaysia is a federal system, which means that there is power sharing. So on the one side, we have states, like Selangor, Negeri Sembilan, and Kelantan. And then on the other hand, we have the Federation of Malaysia as a whole. So that means that the rule that governs their relationship is the Federal Constitution. It sets out the rules. So everybody must follow the rules, the states as well as the whole Federation of Malaysia. So under this, the Federation of Malaysia principles, we have what is called this concept of legislative competence. Okay, to make it very simple, the states can only make laws which are under what is called a state list, and Parliament is of course our lawmaking body for Malaysia. Malaysia can only make laws which are covered under the federal list. Then we have a third list, which is the concurrent list. Concurrent list means both of them can make laws. So what are in these lists? Everybody should have one of these. This is our the Federal Constitution of Malaysia. And if you open up towards the back, you have what's called the 9th schedule. This is 9th schedule. And in this 9th schedule, it shows us these 3 lists. So examples of what's in the federal list. What are the things that Parliament makes laws? These are things like foreign affairs, national security, things like that, citizenship. So states cannot make law about this. If they make laws touching on things which only the Parliament can make, it's invalid. It breaks the rules. On the other hand, it works the other way. There are some things which only the states are allowed to make rules for. So if Parliament make laws which are in the state list, that breaks the deal. That goes against the rules. So the Federal Court has the power, of course, to resolve these so-called contentions. And what the Federal Court has done today, and the significance today, Ibrahim, is that it reminds us of the rule of law, because the Federal Court has declared that one particular provision of the Sharia criminal offences enactment for Selangor 1995 is unconstitutional, which is Section 28. That refers to sexual intercourse against the order of nature. This is not the first time it's happened, all right, Ibrahim? So this is not like this big groundbreaking thing. It's happened a few times before, and it's a good sign that the Federal Court is vigilant to protect and balance the rights of the states and the federations. So there's none of this political stuff. There's nothing about who appointed which judge. No, not an issue, because this maintains the principle that the rights of the states and the federation is balanced. How's that sound, Ibrahim?
It sounds extremely simple. Let's deep dive, right? Now, all this came about because in 2019, a young man, 35-year-old man, whose identity has been withheld at the request of his lawyers, and of course his lawyers, Surendra Anand, and as well as Malik Imtiaz Sarwar, says that the crime that he was charged with, the Section 28 of the said law, which is the Sharia Criminal Offences Selangor Enactment 1995, is invalid. And he is claiming trial to the proceedings, which state pending the outcome of the constitutional challenge at the Federal Court. And now that the outcome of the Federal Court has come out, the man would, I guess, assume to not be continue to be undercharged by this particular act. So yes, this is an issue that came out from a story that happened 2 or 3 years ago, in fact, and it's been resolved today. And you did mention just now that it has not been the first time that the state oversteps its boundaries. My question to you now is, if this keeps on happening, i.e. states overstepping their boundaries, what is the recourse that, or what is the measure, the control measure to ensure that it doesn't continue to happen in the future? Or there's no other way to do this but to just continuously challenge every time it does? Which one is which, Arik?
All right, that's the front-loading approach, and then there is, of course, the litigious approach. The first approach, meaning to say at the stage of drafting itself, you know, at the lawmaking stage. So when we're talking about this Sharia Criminal Offences Enactment 1995, I imagine that in 1995 or 1994 thereabout, the relevant officers would have sat together with the relevant members of the EXCO and discussed this before tabling it to the State Legislative Assembly. And perhaps they would have advised the state government at the time as to, hey, you know, if we have this part of the law, most of the law is okay. But if we have this particular provision, you know, it sounds like something that might be covered by the Federal Penal Code in the Federal List. So maybe in 25 years, there could be a challenge at the Federal Court that will declare all of this unconstitutional. So what do you think, guys? So I think it, you know, I mean, save the trouble and make sure that our drafting and all this stuff is tip-top, right? So the second way, of course, is the litigious way, which is, yes, as you rightly put it, Ibrahim, as and when there is sort of a breach or where either federal oversteps the state or the state oversteps the federal, then there will be a challenge. It's not like these things keep happening. I mean, it has happened in the past, but it's not something that happens all the time. I mean, this incursion, if I can put it in a layman's term, it happened, I mean, 1994, 1995, not like now or 2 years ago. Happened a long time ago. It's just that nobody took it up to the Federal Court, or the Federal Court was not seized, or was not the right case not brought before it. So what are the reasons? I can't explain it. I don't know. But it could be a similar reason in other parts of our legal system, not just Sharia, but other parts of civil courts. Because like, how many people, in terms of access to justice, how many people can afford a lawyer to take the case all the way to the Federal Court? And, you know, I mean, these cases, right, these Sharia cases, their offences, the punishment is much lighter compared to the Penal Code. I mean, for this sexual intercourse against order of nature, this Sharia one, is 5,000 ringgit fine, or 3 years imprisonment, or 6 strokes of the rotan. So a lot of these cases, I mean, the law is not so developed on the Sharia criminal side because a lot of the time they just plead guilty. So there are no judgments. Compared to, let's say, in the civil side, there's a larger number of decisions because they are challenged more rigorously because the penalties are heavier. And Ibrahim, kesianlah juga because this guy, I mean, you know, sure the Sharia offense is struck out, but that exposes him to even worse. The Penal Code one is up to 20 years, you know. So instead of facing the Sharia offense where the imprisonment is only up to 3 years, the buggery one under the Penal Code is much heavier. So I don't know if he got a better deal out of this. However, I think the nation wins lah because we are reminded of federalism. Did I go off?
No, you didn't go off. So to remind the audience right now, we're talking about the Penal Code section 377A and 377B, carnal intercourse against the order of nature. Any person who has sexual connection with another person. I won't complete the entire thing. The 377B, you can actually Google it yourself, go ahead. Committing carnal intercourse against the order of nature voluntarily commits carnal intercourse, right? And of course, you're right. The Penal Code already addresses this. So is this, for being a former DPP, sorry Arik, I got to out you out there, but being a former DPP, is this a wrong strategy that was deployed by the prosecuting officer at the Selangor stage?
They just do their statutory duty, or what they think was their statutory duty, which is, they have SOPs whenever they receive investigation papers from the state religious enforcement agency. They must see whether the elements of the offence has been fulfilled evidentially. Are there witnesses who witnessed this attempted sexual intercourse against the order of nature? And if the goods are there, then it's their duty. If they have no other good reason, they have to just proceed and file charges. So at the prosecutor stage, at the ground level, they're not there to think about, hey, is this law constitutional? They have every reason to assume, because they do this day in, day out, that, the job that I'm doing, the laws that I'm enforcing and prosecuting are constitutional. After all, it was passed 25 years ago. Where can I go wrong? So today, it'll be quite an eye-opener for them.
Okay, Arik, how many people have been charged under the Penal Code, Section 377A or B? Is it a lot of people?
Sorry, Ibrahim, I just don't have the numbers for that. But mind you, being charged, being tried, being convicted are different things. And sometimes cases are not proceeded, even though there are evidence to do so. But sorry, man, I don't have the numbers.
No, it's okay. All right, let's conclude this conversation right now. Do you think that the Selangor State Assembly can challenge this judgment or verdict from the Federal Court?
Oh, it's going to be tough, because the Federal Court is where it stops, right? They are the highest court of the land. So for this particular case, it should end here. Of course, there's this Rule 137. This rule which recognizes its inherent power to review its own decision. I don't want to go there; it's too technical. But this is as high as it goes. What they can do is they can revisit their state shariah enactment and maybe look at some law reform, and maybe they can look as to are there any other laws which could which might impinge or touch on things that the state legislative assembly should not. Any other federal list stuff. Maybe do some law reform so that we avoid this kind of litigation in the future.
All right, fantastic. Thank you, Arik, for spending time with us. That was Arik Zakri, advocate and solicitor with the High Court of Malaya. We'll be right back after these messages. Continue to be with us on Astro AWANI.